All right, thank you so much. Welcome to Fraud in America. I am Jackie DeMar. We are here in person at Georgetown Law School's McDonough Hall, and we are here with the Corporate Crime and Anti-Corruption Georgetown Law Student Association. Thank you so much for inviting us to join you today. We appreciate it. I am here with our special guests today, Jamie Landolt and Linda Severin. Jamie was a whistleblower in the case against Mallinckrodt, which resulted in a $234 million settlement with the government. And that case involved underpaying rebates and lying about it in violation of the False Claims Act. So I'm going to go to Linda really quickly. She was Jamie's lawyer in this case, one of them. Very wonderful False Claims Act lawyer, has been practicing a really long time. Linda, could you give us really quick a little bit of your background, and then a little bit of background on the False Claims Act, and then a little bit of background on the case?
Okay, first, thank you for having us here to talk about this. My background is that I spent my early career as a federal prosecutor in New York City in the Southern District of New York. I then had a stint in private practice in Seattle where I both represented corporate and individual defendants in white-collar matters, government investigations. So I was sort of on the other side of the whistleblower problem and whistleblower cases, and I defended some whistleblower cases. So I've seen it from both sides. I also worked in-house for a time at the Boeing company. After moving from Seattle to Boston, I became a whistleblower attorney in 2010, and I've been doing that work ever since with the Whistleblower Law Collaborative.
Great. And then could you maybe tell us a little bit about the False Claims Act at a very high level?
Yes. So the False Claims Act is a wonderful, powerful statute that incentivizes people like Jamie, who are known as relators, R-E-L-A-T-O-R-S. I passed the International Association of Realtors on my way here. It's almost that, but not quite that, relators, which incentivizes relators to blow the whistle if they're aware of fraud that affects government programs. If federal taxpayer dollars are affected, the Federal False Claims Act comes into play. And there are comparable state False Claims Acts as well. So if you commit fraud against Medicare, Medicaid, on government contracts, government grants, anytime taxpayers lose money as a result of fraud, there is a remedy under the False Claims Act civilly, and the whistleblowers, private persons who are aware of the misconduct, like Jamie was, can bring it to the attention of the authorities, file a lawsuit called a qui tam lawsuit, which we whistleblowers do on behalf of our clients, and if the case is successful, they're entitled to between 15% and 30% of the ultimate recovery. In our case, Jamie got a 20% relator share of the $234 million settlement.
Thank you. And then, speaking of your case, can you give us kind of a high-level breakdown of what your case was about, what kind of company Mallinckrodt was, and what they were doing?
Mallinckrodt was and still is a pharmaceutical company based in St. Louis, Missouri. Jamie was an employee there. They had a drug that they acquired called Acthar, A-C-T-H-A-R, which had been on the market since the 1950s and had been used for a variety of indications. That drug, and I don't have the pleadings here to show you as a visual aid, but that drug for a long time was priced at around $50 a vial. After Mallinckrodt purchased it, it went up to $28,000 or $29,000 a vial, and ultimately sold at a price around $40,000 a vial. This created a huge, so if you look at the chart, it goes like this, and then across. Yeah. The government put that chart in its complaint. And the effect of that was, so there's a program called the Medicaid rebate program, which is highly technical, but basically it requires companies to pay a rebate to the Medicaid program if they increase their drug prices above the rate of inflation. And clearly, this was a price increase way above the rate of inflation. So the company wanted relief from the rebate liability, that it would have. So in 2012, they went to CMS, the Center for Medicaid and Medicare Services. There's always two M's in there. But, it should be CMMS, but CMS.
CMMS.
And presented them with a bit of a sob story about how the rebates were too high, and said that because Acthar had been approved for a new indication, meaning to treat a different disease than had previously been approved by the FDA, that they wanted to reset this important marker for the Medicaid system called the Medicaid rebate system called the base AMP, base average manufacturer price. If it's $50, it was $50 before. When they raised the price, they were hoping to set the base AMP at a higher price, because if the cost of the drug increases above the rate of inflation, you have to rebate the difference. So if the base AMP, instead of being down here, is up here on that chart we talked about, the amount of the rebate liability would be much less. And they succeeded in sufficiently confusing CMS to think that it was a new drug that had been approved, because it was approved under a new number, that CMS at first said, well, it got approved under a new number, okay. And then within a year or two, they realized that that was completely wrong, that the FDA had never approved it under a new number, that it was the exact same drug it had always been, that they hadn't changed a thing about it, and that there was no basis legally whatsoever, to move the base AMP from what it had been up here and thereby decrease their rebate liability. But they got away with it for a while. Until CMS came a-calling when they figured it out. And that's where Jamie comes in.
And Jamie, so let's switch over to your role here. So can you tell us a little bit more about your background and then how you kind of came to work for Mallinckrodt?
So I have an accounting background. I got an accounting degree for the University of Missouri, St. Louis. I also have a master's of business administration, and I held 2 professional licenses, a certified public accountant, and I was also a certified fraud examiner. Started my career in the mid-90s with PricewaterhouseCoopers in the St. Louis office, mainly doing external financial reviews, and then moved over to a company which everybody used to know, but it's been a while, but Anheuser-Busch, which was the largest beer manufacturer in the world. Spent a majority of my career there, moved up from an internal auditor all the way to, I was the executive assistant to the CEO and president of their international division. Ended up leaving there in 2009. They got bought out by another company. And I jumped around a little bit, worked for Stanley Black & Decker in their international audit for a while, but then ultimately in December of 2012, I took a job with Mallinckrodt Pharmaceuticals. They were actually at the time a subsidiary of a large medical device company, a very small portion, and so they were being spun off, and they needed someone to come in and run their internal audit department. And I was there for about 3.5 years before I was then promoted to be the director of internal controls, gross to net accounting, and government reporting, which was the position for which this all relates to what we're going to talk about today.
And so in that position, when did you start to think, okay, something might not be right here?
So I was moved over into that position as part of a management trainee swap in about November of 2015. So I had been in it about 6 months. April of 2016, there was a letter from CMS basically saying what Linda had talked about. They were challenging the fact that we had a different NDA number for our filings than what was originally approved, and the base AMP was not correct. That basically is what they were saying. They said pretty much that they wanted us to immediately to correct the issue and to make the government whole with any back paid liabilities, owed amounts. Mallinckrodt, very quickly, got together. They wanted to be very diligent in responding to CMS, but they needed to do their research. This was the first letter that was received internally. So the response to CMS was basically pretty simple. It was pointing back to, the approval. I mean, they had a letter that said this was okay to do.
How much money did they owe at the time?
At the time,
By then?
by then it was already up to $220 million. And then also ACTHAR on an annual basis was bringing in another $100 million. So this was going to grow quickly.
Yeah, so the little switcheroo they did took effect the first quarter of 2013, and it wasn't until 2016, April, the second quarter, that CMS, sent their note to Mallinckrodt asking them to correct it. And it's also important to know that the Medicaid rebate program relies on honest self-reporting by pharmaceutical companies. The government doesn't come in and tell you what the right price is. You're supposed to report it honestly. Right. So they had, for all of 2013, all of 2014, all of 2015, and part of 2016, been reporting it improperly. And Jamie's department was tasked with calculating what the accrued difference would be at that point if they were actually to do what CMS asked. And it was very high already. So alarming, quite honestly, especially because they had just bought this drug 2 years earlier. They had paid a lot of money for it. And so that would definitely affect the financials related to, the return on the asset that they purchased. It was our flagship brand. So this went back and forth for a few months, and it was always, we had a lot of internal meetings going on, a lot of discussion. But then it was silent for about 6 to 7 months. CMS hadn't responded to our latest response. And then in the spring of 2017, CMS resurfaced with another letter. And they took a stronger stance, and they were basically pushing hard as to, they were standing by their decision. They said, no, you need to fix this. We believe we are correct, and you need to change things. So Mallinckrodt, had to dig deep. They had to do just more than point back to the original letter. So it was really going for, what do we do to justify this? We said $220 million payment with $100 million annually. It was looking to be pretty much a real potential liability. So then, or go ahead, I'll let you.
No, keep.
Well, it's just to interject, Jamie's being very polite.
We don't need to be polite.
My view is that they basically just played rope-a-dope. Like, we have this letter that you gave us. We like what that letter says better than what you're telling us to do now. We're going to stick with that letter. And we're good. Go away. And that was their position in 2016. When they came back in 2017, that was their position. And no, we still think that's right. But, we appreciate the dialogue we're having back and forth, and let's keep talking. And while we explore together this difficult, issue, and then Mallinckrodt would wait for CMS to come and smack him upside the head again, basically. It was not a meaningful engagement with CMS, in my opinion.
And so after the next letter, then what happened? So what happened
That's basically
next?
when I started to become suspicious about what was going on. So I was not involved when they bought this drug in 2014, so I didn't have any history behind it. And I'd only been in this position for 6 months, and I had no background in government reporting. So I'm sitting in a group of individuals that probably has 100 to 200 years of government pricing experience, and I have 6 months. So that was a little bit to my advantage being new, because I sat around, I didn't speak much, and I just listened. And one thing, when I don't understand something, I roll up the sleeves and I learn it. So things weren't gelling for me. The reasons and the responses we were giving to CMS fundamentally didn't agree with the basics of the law. And so, still at that point, I'm thinking, I must be wrong. But, we've got to some meetings, and there were some discussions about, we need to be careful with CMS. We don't want to go to war with them. It's a war, we cannot win. We will only lose. And so hearing that, I'm just sitting, listening, and it's like it felt like there was no intention to resolve it, similar to the rope-a-dope, The responses were really stalling. To me, it felt like that they were stalling efforts. A few things, too, when I mentioned what they paid for it, I got to thinking leadership was in a big dilemma here. They overpaid for this drug, and if you ask yourself, and it was never brought up on Wall Street, no one questioned leadership over this. If you do your due diligence in buying, it's a pharmaceutical company buying a drug, you definitely should investigate government pricing on it. So you have to say to yourself, did they know about this? Well, they should have.
Right.
And if they didn't, it's pretty much gross negligence. So then knowing that, they go in and they pay $5 billion for this drug that has a significant risky base amp that could blow up your entire financial model. So, that was something very interesting to me, and when I took a step back. And then I also, during one of these meetings, I did have the courage to ask a question. And I said, ignoring everything that we know, let's say, CMS has said nothing, and we want to get this approved for to treat infantile spasms, which is what it was awarded on. I said, if we submitted the paperwork, would it get approved? And it was dead silence. And you're talking everyone in the leadership team was in the room. Nobody wanted to answer the question. Everyone was staring at each other. And so then I knew something's not right here. And then the final straw that broke the camel's back was they had a new legal counsel come in. And that new legal counsel was brought up to speed on the case and took a position that we had discussed thoroughly the year before, and we had basically ruled it out as a viable defense. And during that call, when this individual talked about that's what we were going to go with, no one brought up that this had been discussed before and said that it wasn't a valid defense to go forward with. But everyone was happy that now a lawyer was taking a stance and wanted to move forward. And that was about 2 weeks before I ended up leaving the company.
Yeah, so at the point where the straw has broken the camel's back, what did you do next? Kind of, what was your next move?
So I knew I couldn't stay at the company. But, it was I got lucky.
Yeah.
Mallinckrodt was in a lot of trouble. I was able to mask my leave pretty easily. They had more than one investigation going on, and they were a big defendant in the opioid lawsuits that were very big about 5 to 6 years ago. So the writing was on the wall that that company was going to be hurting. So I had an opportunity to I got a position at the Mayo Clinic up in Rochester, Minnesota. And when I left, the dialogue with CMS was still going on. It was open. There had just been a response. And so me leaving, I don't really think it left any bells that I was running away to file a lawsuit against them, and I really wasn't.
Yeah.
I knew what was going on, and I knew how it was being portrayed, but at the time when I left, everything was still, there was, I guess, relevant discussion with CMS going on.
So there's ongoing discussion still when you leave, but...
Yeah, I wanted to keep my eye on it.
Yeah.
So I'm going to jump into the next.
Yep.
So I had some internal sources. I knew what, in my heart was that the hopes would that CMS would go away. So I knew the longer it went, the more difficulty it would be to resolve the situation. And it was getting to almost a year, about 10 months since I had left, and I had found out that CMS had not responded back to the last correspondence in July 2017. So I knew I needed to do something.
And one important point to mention here is that the more time goes by, the greater the amount of rebates, unpaid rebates, the amount of that grows. So each month, each day, each quarter, each year that this goes unresolved, and Mallinckrodt doesn't respond to CMS's requirement that they change the base AMP and improve their reporting, they're paying millions, tens of millions of dollars less in rebates than they need to.
Right.
So the stall and run out the clock strategy, is to their advantage, at least in terms of short-term, their cash flow.
Right, absolutely. So nothing's happening here. This is going on and on. is this when you decide you need to find a lawyer and do something about this, and you go find?
It weighed on his conscience.
Yeah, yeah.
My moral compass, right? That's what we
And you had a very different experience than a lot of whistleblowers, especially internal whistleblowers that try to blow the whistle. Maybe they report internally first in their company. A lot of people get fired. They have to go through a lot of retaliation internally in their company. You mentioned earlier you got lucky because you were able to kind of extricate yourself from the situation, find a new job, and then kind of move into this kind of second phase of your reporting, and find a lawyer and not kind of suffer that retaliation afterwards, which is obviously a good thing.
Yeah, correct. Yeah. It would have been career suicide for me to speak up, to be honest with you, and try to push back. There was nobody at the table that was saying, otherwise.
Right.
And so I was the lowest level employee. So you're talking all vice presidents, senior vice presidents, top leadership. If some director of gross to net accounting and government reporting is going to speak up, it would have been pointless, quite honestly. So I started looking for someone that was familiar with this, and I actually searched quite a few places, and it's not easy. It's the most important step, I think, if you're going to be a whistleblower, is to find the right attorneys for your case. And I struggled because the first firm I went with, I didn't go with them. My first firm I contacted really wanted to sign me on, but they weren't hitting the smell test with me as being a viable candidate for this case. I then Googled largest firm to win a suit this year, found them, and they weren't convinced I had a case. I knew I had something though, and I remembered an email that had been circled about a case with another company on the EpiPen. It was Mylan, and it was a similar case as in the ballpark of rebates as like Mallinckrodt. Mylan was not paying their rebates as a branded drug, which would be higher. They were paying it as a generic drug. And so they were way behind as well in what they owed the company. But anyways, a similar case to what I had.
A case our firm handled that settled for $470 million, I think. Yeah.
Yeah, and I Googled and found a picture of Linda and Suzanne at a table with stacks of paper. And I anonymously filed. And when you're a whistleblower, you have a lot of anxiety and fear, and it's mainly because of the unknown. I mean, you really don't know what you're getting yourself into. You kind of paralyze yourself. It's much easier to walk away. It's not the right thing to do to walk away, but you have a lot of grief. But the minute I spoke with them, I knew how well versed they were in this law, and they were more up to speed than my leadership was where I worked at Mallinckrodt. So I knew I was in good hands.
Yeah. And so once you found Linda and Suzanne and the Whistleblower Law Collaborative, so you guys are working together now. Linda, kind of, what was like the intake process like? Kind of, how did you take Jamie on?
Jamie contacted us via our website where we have, an intake form where someone can just, send us a little note and say, I'd like to talk to you. Here's my contact information. This is the information I have. Thanks to the firm's prior experience on the Mylan case, we were very familiar with the Medicaid drug rebate program. So we pretty much jumped on Jamie as a potential client. He came to us, and we were aware that there was this letter that I think scared off one of the other firms he spoke with. But we thought, well, why not work the case up, send it to the government in a pre-filing context, and get a sense of whether this is something that that they think is a viable False Claims Act case. And we were encouraged to go forward with it, and CMS and the government proceeded very aggressively after we filed the Key Tam case. We filed the case in September of 2018. Jamie contacted us in late May. We had the complaint on file in September of that year. And then things started getting very interesting for Mallinckrodt because they were still doing the stall with CMS. The liability was continuing to grow, and CMS got tougher and tougher and basically said, you need to pay this money or we're going to lock you out of the system and you can't be reimbursed by Medicaid, which is
the worst thing you can do.
The worst thing that can happen to a pharma company. So there was a few months of dialogue with CMS that we learned about later. That was all behind the scenes, but our complaint was pending. DOJ then served the company. This was a bad few months for the company, let's just say, with a civil investigative demand, for documents and information. So they now know that there's an active False Claims Act case. CMS is cracking down on them. And so their next move was not to say, let's work this out, let's pay the money. It was to run to court in DC. Our case was filed in Boston. Run to federal court in DC and sue CMS for daring to try to make them set their base amp to the appropriate level. So there was this litigation happening in DC that took about a year to play out, which they lost decisively, emphatically, and with very colorful language from the judge rejecting their arguments, which I read periodically.
Just for fun.
Just for fun, yeah. And it was appealed to the DC Court of Appeals on an emergency basis, was shot down there, and only then, and I think that was June of 2020, I think, only then was the base amp of Acthar reset. So Mallinckrodt got the benefit from January of 2013 to June of 2020 of underpaying the rebates. And the number that Jamie gave earlier for when CMS first came knocking in April 2016 was like 225 million, had by that time grown to 650 million. So that was the single damages figure for purposes of the False Claims Act.
Yeah. And so your complaint was filed 2018.
September.
And this case was crazy quick. You mentioned that the government was very interested and got involved quickly and moved fast. I want you to talk a little bit more about both of your experiences working with the government, because you had an extraordinarily good government team that you worked with. But most of these cases take, anywhere from 5 to 10 years, and your case was basically under 2 years and settled, right?
Yeah.
Wow.
And it's not small either.
No, it's
650 million.
Yeah.
So that's really crazy.
Right, and we'll get back. So 650 million single damages. I mentioned earlier the settlement was $234 million. So we'll talk about why that is in a couple minutes. But let's talk about your experience with the government, Jamie. How did you work kind of with the government once they started investigating the case?
So immediately I was flown to do an interview up in Boston. And pretty much all my interaction with the government was through my legal team. I never had any direct contact with them. But as far as working with the DOJ, which was the majority of what I worked with, I'd say it was a very pleasant experience. I mean, I was very intimidated at that first interview when I went into.
There were a lot of people there.
Yeah, they brought in a lot of people and they brought big stacks of information, and I'm staring at all this. I'm like, what did I do wrong? But it was like I had said before. Mallinckrodt was under investigation for other things, and I think there might have been some other things that they thought I might know about. But I'm just speculating here. But there was a lot of people, a lot of information. But I mean, the communication with my team was excellent. It was constant. I couldn't believe the writing, the arguments, our positioning. It was top notch. Really counteracted and made, I felt, Mallinckrodt's arguments look silly. There was other things as well. I don't know, Linda, anything to add to that?
Well, I would just say, as an attorney representing someone like Jamie in these cases, it's so much easier for us to sort of keep our clients grounded, and it's so much easier for us to work with the government towards a successful resolution if they communicate with us. If they're honest with us, they tell us where they are in the process. They don't have to tell us all of their investigative steps. But, you don't want to file your complaint and have it go into a black box and have the government say, we'll let you know when there's anything to report. This team was very, very good at communicating with us about where they were, what challenges they might be facing. And it made a tremendous amount of difference, both in terms of, I would be doing my own research and I would pick up the phone and call the AOSA and say, hey, I just found this piece of evidence. They'd say, great, and it found its way into their complaint that they were writing, their complaint and intervention at the same time we were writing our amended complaint when they were intervening. So that kind of, very, as open as you can be with one another as colleagues almost, because you really are, to make it a meaningful partnership under the False Claims Act really makes these cases work well. And this team had very experienced attorneys who understood that, had worked with our firm before on the Mylan case. At least two members of the team had. So there was a trust that had already existed based on past experiences with us as attorneys. They knew they could trust us. We trusted them in their communications with us. So there were no games. Nothing was hidden. And I think that made it very easy to move quickly together. And it also helped keep Jamie grounded, because you don't want to file a whistleblower complaint and then just be left chewing your fingernails wondering what's going to happen. And are you going to be named publicly? Are you going to make money? Are you going to not make money? Is the case going to be settled? Because of the government team's professionalism and transparency with us, it was a really, really successful partnership.
I think one thing that was different in this case too is they were aggressive. Yeah. And it worked, I think, really heavily in their favor. When you put a public company out there and they have to respond quickly, they haven't had time to think about it. They have to issue a public release when that happens, and I think they caught them off guard. And then the other thing I'll say is, and everyone might not be aware, but 20% is a huge reward based upon the average. To know that the government was not going to get the full 650, it was only going to be 234, and to still give me a higher share than what is normally given, that really makes me feel I was heavily considered as an important piece of this process. Something really good to feel about because you're not assured anything. Mm-hmm. So I felt very valued by the amount that I received. Absolutely.
Yeah, that public-private partnership is so important in these cases, and it is excellent to see that it worked so well in this case. So let's talk about kind of
why it was a $234 million case, not a $2 billion case.
What happened here? Yeah, can you talk a little bit about the bankruptcy and where we go?
Under the False Claims Act, the measure of damages for under the statute is either double or triple. It's treble damages. So 650 million times 3 would be, very close. When you add interest in is, $2 billion. And in fact, Mallinckrodt had filings with the SEC and I think with the bankruptcy court saying that the potential liability from this case was $1.95, billion. So that's what they faced if they were to fight it. For False Claims Act cases that are settled, DOJ will typically settle for double the single damages. That still would have been a lot, $1.3 billion. And in this case, and I'll never forget in the phone call from the government, we had heard rumblings that Mallinckrodt was in financial difficulty and might be declaring bankruptcy. And we got a call from the government saying they had what's known as a handshake agreement, which is an agreement in principle with a False Claims Act defendant, that to pay $234 million. And you would think as a whistleblower attorney, getting told that there's going to be a, $234 million. I mean, those are big settlements in this space, that I would have been happy. And I was really, really upset and disappointed, because what it meant is that not only would we not get double damages, which would, be a punishment and a deterrent to this kind of conduct. But, the government wasn't even getting back the money that Mallinckrodt had improperly failed to pay it. They got less than half of what, was essentially, they defrauded from the government. So while I was happy for the settlement and happy for Jamie, it didn't seem like a just result.
Right.
And think about the amount. When I originally told you, the liability was only $220 million. They could have knocked this down right away and been done with it and probably been on a better standing with the government. But by dragging it out and doing what they did, they added
they turned a $220 million problem into a $2 billion problem. And the only reason it wasn't that big is because, they declared bankruptcy.
But you really, I think this case, maybe the numbers aren't necessarily a deterrent because of the way that this case shook out. But I do think that you could say that, this case serves as kind of could change in industry practice in this area, right? Like, I wouldn't say that,
Oh yeah, by no means. The takeaway here is not that we are in any way disappointed in the process or the result. The government should have gotten more money back, but this is the point you're about to make, the ongoing benefit to the government of the reset base amp.
Correct.
Go ahead.
Well, no, go ahead, because there's another thing too, so go ahead.
All right. So by resetting the base amp, from now to time immemorial, they can't claim that higher base amp and get the benefit of the reduced rebate. And at one point, I'm not sure what Axar's current sales are, but at the time of the settlement, the estimate was that would save the government $90 to $100 million a year. Those would be additional rebate amounts that it would be getting that it would not have gotten without our case, without our settlement, without the restatement of the base amp. So that was a benefit over and beyond the $234 million. And there is definitely a deterrence in the industry. If other pharmaceutical manufacturers are playing games with the rebate program and they see aggressive enforcement in this area, they might think, we better straighten things out ourselves and not be in the kind of situation Mallinckrodt is in, where you're either facing, a 1.3 if you settle or a 2 billion plus if you don't, or you're in bankruptcy. None of those are happy places for a company, when they could have worked it out when they first were contacted.
So Linda, did the law change now? Because I remember, so manufacturers are required to put their price into the system, and CMS couldn't change it. And they would tell you to change it. And now I believe, am I wrong, that CMS has the ability to go in and make the changes if a company refuses? I know they were working on that law. I'm not sure.
I'm not sure the status of that, but
okay.
I think
there was discussion about getting that changed, which would be an outcome of this case, so that if manufacturer disagrees with CMS, CMS could go in and change it and not have to wait for a manufacturer to do so. So that was the point I was going to make.
No. It's a case that makes waves regardless, right? Do you have anything else to say about the case itself? Because I wanted to kind of ask you, Jamie, a little bit of some bigger picture questions.
I think we've covered the case.
Yeah.
So I know in your case, we talked about how you kind of got out without having a lot of retaliation or being blackballed in the industry. But you also mentioned that there are a lot of potential negatives of reporting. You want to talk about kind of what you see as some potential negatives of whistleblowing?
Sure. Yeah. My first concern, the negative, was what if I was wrong? I mentioned that only 6 months of experience, and also too, would anybody believe me, being my junior status with the firm? As far as retaliation, retribution, or physical harm, I never felt any of that. I was never worried about it. I do say it is real, though. You obviously have seen some of that. And in my case, when I went to my new organization, no one knew. I was obviously under seal But when it was released in March 2020, my name, I let my supervisors know, just to be transparent with them in case for some reason they would find out. And it was worked up the chain through leadership, and they wanted to send out an email to all of senior leadership warning them, that we had an informant in the organization. And those weren't the words that were probably used, but they wanted to be cautious around, these individuals. And so basically it felt like to me, somewhat of a retaliation. Luckily, I had a great chief risk officer who saw the flag there and put a stop to that. But in terms of physical harm or anything, that was probably the most of it. One thing though that was weird, I had some of these people were my friends, so some damaged relationships, obviously, because they were caught up in defendants in the lawsuits. And some people that weren't even in the lawsuit, I think a word I would say is I think it's better off to not be associated with me, which to me is very sad for them. Yeah. I think your priorities are messed up if that's how you feel. My favorite is the industry backlash that everyone fears. And I'm going to tell you right now, when you're thinking about doing it, it's there, it's real, but it's a myth. It's funny to believe that the people who commit these frauds, they're not worried about industry backlash, but the people that are going to report on them are worried about it. That's kind of a backwards society. One thing too, if you don't report it, you're typically a key witness that's going to be subpoenaed anyway, and you're going to have you're going to have to do all that work, and then there's no potential for financial. So we tend I say in this day and age with social media, we think a lot higher of ourselves than, and I don't mean to say we're all somebody's, but in the whole scheme of things, who's going to remember our names? So I would say your actions will last longer in the future than your name ever will. And if that action's doing the right thing, then you shouldn't have anything to worry about with coming forward to report. So, I think am I missing anything there?
I don't think so.
I think those are the...
a fear of being blacklisted is very common, and it can prevent whistleblowers from coming forward. But I think what Jamie's saying is the reality is, I don't know that they're going to keep a list of everyone who's filed a key TAM action and circulate it through the pharmaceutical or medical device industry so that people are blacklisted. I think the fears are overblown, and Jamie came to us with a lot of fear and anxiety, and having come out the other side, he looks back on that and feels like that was overblown, which isn't to minimize that there can be real harm to people in more vulnerable situations than he was in. But
so a couple of things. I speak at some universities. I've done a few already, and I always show slides of people who've done some really bad things, and I start with their name. Nobody knows who they are. Then I show their face. Nobody knows who they are. And so, and some of these people have robbed banks. They were serial killers. There was a nurse that was killing patients. So, and in my case with the Mallinckrodt, I'll never forget when the announcement was made. It was on the AP News, first line, major announcement, 7 a.m. Well, whoever wrote the story didn't put my name in it. And then it was edited at like 11 o'clock and my name was put in it. By 1 o'clock, it wasn't even on the top feed. So we worry ourselves, I think, unnecessarily for situations like that. The reality is I wouldn't worry about that. Just do the right thing to do.
Well, so I think that you can answer my next question. You just answered my next question, which is, would you do it again, knowing what you know now?
Absolutely, with no regrets. Walking away is not an option. Think about the message it would send by doing so. With that in mind, thinking about that $650 million too, that money was meant to fund Medicare and Medicaid programs for the needy, sick, and elderly. And that was always a funny argument by Mallinckrodt because they were worried about that drug treating a specific indication, a very rare disorder, but yet the $650 million that was denied for the programs, that basically all of us will be looking for our health care eventually for. I talked about, it's an overrated impact. Everybody thinks they're famous, but you're more infamous, which is better. Honestly, it is better. And then I do think, though, on the reflection, my biggest disappointment is that the consequences just don't match up right now. People are, if they're even sorry, if these people are sorry for what they did, I don't know that they are. They're only sorry they get caught. We need to start making sure that they're sorry they did it in the first place. And that's going to take a lot of change and a lot of enforcement, maybe some reset precedent, but it's the way to go because it's still happening to this day.
Hear, hear.
Well, and that goes back to the whole issue of whether you hold only the entity liable for wrongdoing or you actually pursue individuals, because at some point without individual accountability, it's a cost of doing business, and you have some businesses that have a higher risk tolerance and will push the envelope, and if they get caught, they'll pay, and if they don't, they'll keep breaking the rules.
And Mallinckrodt was funding, we believe, all of the legal counsel defense for this, even on the individual civil liability case is what we feel, which, to me, that's, I don't even know what to say. Incomprehensible, should I say that one? It's just the way it is right now.
Right.
It's how it goes, so unfortunate.
All right. Well, thank you all so much for being with me. Thank you for doing what you did and for blowing the whistle on this bad behavior and stopping that $100 million a year from going out the window. Thank you again to the Corporate Crime and Anti-Corruption Georgetown Law Student Association. Thanks for having us here with you. Thanks to Getnick Law for sponsoring our podcast, and thank you for tuning in to Fraud in America. We'll see you next time.
Our annual sponsor is Getnick Law,
a boutique Manhattan law firm dedicated to fighting fraud and promoting business integrity. Learn more about the firm at www.getnicklaw.com. If you believe you've witnessed fraud against the government or on the financial markets, or want to learn more about the laws that exist to fight fraud, visit taf.org, where you can find a directory of whistleblower attorneys who work across the country. On our website, you can find information about the nation's whistleblower laws and programs, and a way to donate to our organization as we continue to fight attacks on whistleblowers and these laws. Fraud in America is presented by the Anti-Fraud Coalition. Jacqueline DeMar is our host. James King is our executive producer. The website for Fraud in America was designed by Wide Eye Creative. Our artwork is by PPA Agency. And our theme song is by Spatial Relations.